Human resources HR laws apply based on number of employees. Highest number of employees, 20 consecutive weeks. The human resources laws which apply to an organization depend on an employee count. Count the number of employees, parentheses, full, part-time, and temporary, exclude independent contractors, end parentheses, and make a list for the 52 weeks of the calendar year. Now look for the highest number over a consecutive 20-week period. Here is an example of a company's 52-week employee count. 12, 18, 21, 24, 25, 26, 27, 28, 30, 25, 22, 18, 15, 17, 19, 21, 22, 23, 24, 24, 24, 25, 25, 26, 27, 27, 27, 28, 26, 26, 26, 27, 27, 28, 29, 28, 27, 26, 25, 24, 23, 23, 21, 20, 19, 18, 18, 18, 19, 19, 20, and 21. Start at the 12 and look out 19 consecutive weeks. Since there is no lower number than 12, the number is at least 12. Then look at the second week, 18. It fails because there is a lower number, 15, in the next consecutive 19 weeks. Move down the list to the 17 and look out 19 weeks, and it works because all are 17 or higher. 19 works too. 24 also works. 25 does not work. Parentheses, look at each case of a 25 and look out 19 weeks, and for each case, a lower number than 25 is found. So for this company, the number of employees is 24. The WARN law applies if 100 or more employees. Affirmative action, FMLA, applies if 50 or more employees. ADEA and COBRA apply if 20 or more employees. ADA, Title VII of the Civil Rights Act of 1964 and 1991, and the Pregnancy Discrimination Act, PDA, apply if 15 or more employees. All other HR laws apply if 1 or more employees. Lean manufacturing. Lean production. Not valuable to customer, is waste, has to be removed. Lean manufacturing is the concept that anything other than value to the customer is waste, and therefore needs to be removed. The motto of the lean manufacturing concept is, quote, more value, less work, end quote. Think of an engine that when it runs heats up. The heat is energy that could have been used to propel the vehicle. So the heat is waste, and if it can be reduced, translates into greater value for the purpose of the engine. Lean manufacturing is attributed to Toyota's Toyota Production Systems, TPS. The model has been extended to consider the, quote, flow, end quote, of a manufacturing system. Flow is the smoothness of the manufacturing process, which is a, parentheses, consistency first, and parentheses, concept. Consistency first because it is the consistency that leads to quality. Lean manufacturing is considering anything that is not of value to the customer as waste and therefore has to be removed. Synonyms: lean enterprise, Toyotaism. Uniform Services Employment and Reemployment Rights Act, USERRA of 1994. Health insurance and job protection for non-full-time military. The Uniform Services Employment and Reemployment Rights Act, USERRA, USERRA of 1994, protects non-full-time military service members, parentheses, like the National Guard, for example, and parentheses, from hardships of working in civilian employment. USERRA allows service members to return to positions for up to 5 years. USERRA prohibits discrimination of service members applying for work or current employees applying for non-full-time military service positions. USERRA also guarantees health insurance for service members performing duty for more than 30 days up to 24 months. The employer can charge the service member up to 102% of the premium of such health insurance. Less than 31 days of military service, healthcare insurance continues as if normally employed. The Uniformed Services Employment and Reemployment Rights Act, USERRA, of 1994 provides health insurance and job protection for non-full-time military service members. Worker Adjustment and Retraining Notification Act, WARN of 1988. Notice required if 1/3 or more laid off or plant closing. The Worker Adjustment and Retraining Notification Act, WARN of 1988, requires employers to give 60-day notice of a mass layoff or plant closing. WARN applies to employers with 100 or more full-time employees, parentheses, more than 20 hours a week, end parentheses, or 100 or more employees with a combined regular, not overtime, work hours typically totaling 4,000 hours per week. A mass layoff is defined as 1/3 or more of the workforce. Managers, supervisors, hourly wage and salary workers must receive notification and the union representative must be notified. WARN Act exceptions. Quote, faltering company, end quote, means the employer is seeking capital to save itself and announcing the mass layoff would make receiving the financing impossible. Quote, unforeseeable business circumstances, end quote, means that such a layoff has come on the business suddenly. Parentheses, natural disaster, end parentheses, is self-explanatory. The WARN Act applies in bankruptcy if the business continues to run in Chapter 11 reorganization. Penalties include pay for notice failure, up to 60 days. Voluntary payments to employees may be made, quote, in lieu of notice, end quote. The Worker Adjustment and Retraining Notification Act, WARN of 1988, requires employers to give 60-day notice of mass layoff or plant closing. Employee Polygraph Protection Act, EPPA of 1988. Security and pharmaceutical companies can use lie detector tests. The Employee Polygraph Protection Act, EPPA of 1988, restricts the use of a polygraph lie detector test for pre-employment or employment screening, except in certain specific situations. The Act does not cover federal, state, or local government agencies. Polygraph tests are allowed for security and security guard applicants, armored car, alarm, and pharmaceutical company applicants. The Employee Polygraph Protection Act, EPA, of 1988, limits the use of lie detector tests in hiring. Martin v. Wilkes, 1989. Constitutional right to challenge previous consent decree. In the case Martin v. Wilkes, 1989, white firefighters sued because less qualified African American firefighters were given jobs and promotions. The county had signed a consent decree which required them to hire and promote African American firefighters. The court upheld Wilkes's case that he had a constitutional right to challenge the previously established consent decree. Circuit City Stores, Inc. v. Adams, 2001. It is unclear if an employer can force employee arbitration. In the case Circuit City Stores, Inc. v. Adams, 2001, Adams was hired by Circuit City and signed an agreement that any disputes between the employee and the employer were to be settled by arbitration. This is a common clause to avoid going to court, which is lengthy and costly. Many contracts include this clause, like real estate purchase contracts, for example. The case specifically questioned whether the, quote, Section 1 exemption, end quote, of the Federal Arbitration Act applied to an employment contract of an employee at Circuit City Stores. The case made it to the U.S. Supreme Court, who on appeal upheld the arbitration agreement. This all came about after Adams sued Circuit City for employment discrimination. Circuit City responded with a challenge to the case that it had to be decided by arbitration and not in court because of the arbitration clause, which the employee signed as part of being hired by Circuit City. In the end, however, California courts declared the arbitration clause unconstitutional, and Adams did pursue a suit against Circuit City in court. This case has remained a test of the ability of an employer to hold an employee to arbitration instead of court or HR issues like employment discrimination. For HR issues like employment discrimination. Ellison v. Brady, IRS, 1991. The, quote, reasonable woman, end quote, sets what sexual harassment is. Ellison v. Brady, IRS, 1991, is a case where Ellison was continually pursued by Brady. Brady would write her letters which were so far from reality that Ellison became afraid for her safety, with the perspective that she did not know what Brady was going to do next. This case is famous because the opinion of the court involved the language of the perspective of a, quote, reasonable woman, end quote. The, quote, reasonable woman's, end quote, point of view was what determined what sexual harassment or a hostile work environment may involve. Even now, our standard for a hostile work environment or sexual harassment has evolved, and we may consider behavior to be sexual harassment even when the perpetrator has no realization that it is sexual harassment. We expect that a work environment will be neutral, professional, and without acknowledgement of gender or race. Ellison v. Brady, IRS, 1991, is famous for its, quote, reasonable woman, end quote, finding. Theories of tort law. Civil wrong causing harm or loss resulting in liability. A tort is a civil wrong, parentheses, as opposed to a criminal wrong, in parentheses, which causes another to experience loss or harm, resulting in liability for the person causing the tort. The person causing the tort is the tortfeasor. Torts result in lawsuits where the person harmed can attempt to reclaim compensation for damages. Damages can include physical injury, economic injury, or reputation injury, violations of privacy, property, or constitutional rights. Torts may include auto accidents, false imprisonment, defamation of character, product liability, copyright infringement, environmental pollution, and wrongful death. Torts in human resources may include workplace injuries, workplace illnesses like secondhand smoke, wrongful termination, invasion of privacy like substance abuse testing, and negligent hiring. Torts can be intentional or unintentional, as in the case of negligence. Tort lawsuits do not require, quote, beyond a reasonable doubt, end quote, which criminal trials require. A tort is a civil wrong which causes another loss or harm resulting in liability. Fair Credit Reporting Act, FCRA of 1970, regulates collection and management of consumer credit info. The Fair Credit Reporting Act, FCRA of 1970, regulates the collection and management of consumer credit information. The FCRA is enforced by the U.S. Federal Trade Commission and citizen lawsuits. The FCRA regulates what is done with collected financial information, especially when it is used to limit a person, and regulates the storage of collected financial information by third parties, like credit rating agencies. If such information is used in the decision to not hire a candidate, the candidate must be notified of this in writing and told where the information came from. Third-party consumer credit collection agencies are required to tell individuals what is kept in their files regarding that individual, and negative information can be disputed. The Fair Credit Reporting Act, FCRA, of 1970 regulates the collection and management of consumer credit information.